agent, let's know what are the rights of agent. Here, the rights of the agent becomes the duties of the principal. So, what are the rights of the agent? Number 1, right to remuneration. That's given under 219. So, the agent has a right to receive remuneration and it is duty of the principal to give the remuneration to the agent. The next one is right to retain sums. We have discussed it. That's given under section 217 and 218. So, the agent has a right to receive the remuneration. He can retain the remuneration and it is the duty of the principal to give him properly. Whatever the sums is there, he has to receive it as well as the agent has a right to retain in case if it is not given, he is not properly remunerated. The next one is right to lien on the principal's property. That's given under section 221. He has got the lien on the principal's property. That is, who is that? Agent. We'll discuss what lien it is. Next right of the agent is right to be indemnified. In case if the agent incurs any loss, who has to pay for those losses? It is the principal. It is the duty of the principal to indemnify the agent related in such a way. It's given under section 222 to 224. The last right and duty of the right of the agent and duty of the principal is right to compensation. So, the agent has a right to compensation and the principal has a duty to compensate for any damages caused by the principal's negligence. If at all due to principal, if there is any loss caused to the agent, then the agent has a right to be compensated and the principal has a duty to compensate. So, what are the rights of agent and what are the duties of principal? Whatever the right the agent has against the principal, it is the duty of the principal to pay to the agent or discharge towards the agent. He has to discharge his duties that an agent has to get for his work. So now let us know what are the rights of agents or agent, and whatever his rights are there, that forms the duty of the principal. So in short, that is in short. Now, right to remuneration. It's given under section 219 of Indian Contract Act. What is right to remuneration? So, right to remuneration means he has to be paid for his work. He is authorized with certain work by the principal, and when he discharges it successfully, he has to be paid. That is known as remuneration. So, an agent is entitled to his commission in the absence of any special contract. That is, if there is any contract saying that he will be entitled to get so much money, or I'll be giving so much amount of percentage or something, they will enter into a contract for his remuneration, pertaining to his remuneration. If at all there is no percentage or anything mentioned in this special contract regarding this, then he is entitled to get his commission. That is as per your section 219. Your 219 gives that when an agent remunerations become due, when he discharges certain functions which he is authorized to do, and if there is no presence of any special contract, then he is entitled to get his commission. The agent can also detain the goods. He can, he has received certain goods, he can have it in his possession itself until he gets the money from the principal. So, on whatever he has to get, when the amount he has to get rightfully, till he gets it from principal, he can detain it. That is a lien. Others also, if there is any sale, suppose there are some goods given to the agent, and if there is some sale, then the agent can detain that money which he received from that sale. Clear? This is clear, I guess. He can detain the property of the principal, or if at all, if he has sold that goods by the consent of the principal and he has received any money, that is the agent has received money, he can detain it and for his remuneration. So although sometimes it happens that he is having a possession of the goods, although the whole goods, whatever is given by the principal gives it in some bulk. Although not all the goods there have been sold, only a part of goods have been sold. So till the sale here, it means that the actual sale is not complete of all the goods. The sale has not yet happened. So there is only a small portion of goods which is sold. For that only, whatever it is sold, he can have his remuneration as per law. Generally, the sale of goods by agent, it may be continuous process. It is not that the goods are given by the principal, he authorizes him to sell. It is not that he is selling it in bulk. Whatever the goods given by the principal, as it is, he is selling. No, he may sell it in one part, then after a few months he may sell the other part. So it's a continuous process. Therefore, the law entitles the agent to remuneration on the basis of work done. Whatever the work he has done, for that he can take the remuneration. Or if at all there is no remuneration, in the sense commission. If at all there is no special contract regarding this remuneration part, from time to time, that is, whatever the goods he sells, suppose he has sold 10 pens today, for that he can take the remuneration. And next week he is going to sell another 10 pens, for that he has to take that week's remuneration. So he can take it from time to time, and the law has given this authority under the section. However, there is one more important thing to be noted here is, the agent's remuneration does not become due until he completes the work. Until the entire work is completed, his remuneration does not become due. The principal is not liable to pay. So, but this rule is subject to a special contract. If there is any contract saying that, no, after this certain work you can collect the money, then the remuneration becomes due. As per this rule, it says that, please listen, it says that the remuneration does not become due until the completion of the work. Only when the work is completed, then only the remuneration is payable to the agent by the principal. But in case if there is any special contract for this, saying that no, after certain time or after certain part of work is completed, then he can be paid remuneration, then the agent becomes liable, to receive. He can receive, and the principal becomes liable to pay it. Clear with this? So, for that we can take an example. The parties have agreed, both the parties have agreed that, okay, the agent will be entitled to commission when he finds a purchaser for some property. When he finds the purchaser, point number 1, and the point number 2 is that purchaser is ready and willing to buy that particular property. Then the agent's commission, agent is entitled to receive the commission. It is not that, it never said that after the completion of the work. It said that only 2 conditions were given. That is, he is entitled for commission when he finds a purchaser for a property, and when that person agrees, he is ready, okay, he is happy with the property and he is willing to buy it, then fine, the agent gets his commission. The agent will get the commission. Otherwise, what would be the case? After the sale is completed, then the agent would receive the commission, right? So, this is what happened in this particular case. That is Saraswati Devi versus Motilal. What happened in this case was, whatever the example I gave, the same thing. There was a plaintiff who was an estate agent. He was engaged to sell the estate of Srimati Saraswati Devi and her husband's property. They had certain property which the plaintiff, that is the estate agent, had agreed to sell. He said that initially that yes, when he finds the purchaser and who is ready and willing to pay, then he gets his commission. Was the consent given by the principal for the commission of the agent? Accordingly, the plaintiff, that is the estate agent, found a purchaser who was willing to pay 1,27,000 for the property. And they also gave an advance of rupees 30,000. Subsequently, this defendants, defendants refused to sell the property to the customers. They said that no, we don't want to sell the property to the customers. We don't want to sell. They said that they don't want to sell. And now what to do? What happens to the agent? This agent files a case. He files a case against the Saraswati Devi and her husband, saying that he is entitled for a commission. So there it was held that yes, the agent is entitled for a commission of rupees 2,500. Has he found the purchaser who was ready and willing to buy the estate. So that was the condition put forth, and he has found a purchaser. It is now that Saraswati Devi and her husband is refusing to sell that property. It is their decision. So, but whatever duty was given to the agent, he has done it successfully. He has completed successfully. So now, as per the contract, he becomes liable to the commission, to pay the commission. To the commission to be paid by the principal, that is Saraswati Devi and her husband. So this was the case relating to right to remuneration. Under right to remuneration, you have to remember two important things. That is, one is if there is any absence of special contract, then a commission has to be paid to the agent. He can even retain the goods. He can retain the money for after the sale of goods, and if it is only a part of goods are sold and part of goods are remaining, whatever he sells, for that he can take commission. And it is not necessary that but the rule, as per the rule, it says that after the completion of work only here the agent is entitled for commission. But if there is any special contract saying that no, he is entitled for commission and soon after one part of the work is completed, for example. So in case if there is such a contract, then he can be paid, he is entitled for his commission. So the right of an agent becomes the duty of the principal. So it's the duty of the principal to pay to the work whatever the agent has done on authorization by the principal. Now let us know what are the rights of the agent, and simultaneously we will get to know what are the duties of the principal. The first one is right to remuneration. That's given under section 219 of Indian Contract Act. What is remuneration? For any work done by the agent, he has to be paid, right, for his labor or for his any skill which he has exhibited. So he has to be remunerated for that. So your section 219 says that in the absence of any special contract pertaining to this remuneration, if there is no special contract in that, then he becomes entitled to commission. So if there is nothing mentioned about remuneration in the contract, then he has to get his commission at least by the principal. So that is what your section 219 says. Further, it also says that if in case if he is not paid, he has a right to detain the money. That is, whatever the money he gets from the sale of goods of the principal, he can detain that money, he can keep it with himself, the money from the sale of goods, whatever the proceeds he has got from the sale of goods has his remuneration. Clear with this? Although what happens is, see, the principal gives the agent certain goods. It may be in bulk. He asks him to keep it for a year and sell it throughout the year. Now the agent is selling it, let's assume for a month he is selling only a certain parts of goods. So every month he is selling and he is getting certain money. This month he sells 100 pence. Let's assume that he sells 100 pence. So whatever 100 pence he is selling, he has to get commission or his remuneration for it, right? So it says that as per this particular section, it gives that though there is a whole goods consigned, entire goods are consigned to him, it is given to the agent. But still, he may have sold certain things and he may have not sold certain things. So generally, the sale of goods by the agent may be continuous process. That is, it happens continuously. So therefore, the law, entitles the agent to remuneration on the basis of work done from time to time. So this month he is selling 100 pence. For that he is receiving certain commission. Next month he sells certain pence. For that he gets commission. So every month he keeps selling certain pence, certain number of pence, and he gets the commission. He gets the amount. From that he can keep his remuneration, whatever principal has authorized that you'll be getting certain part as a remuneration. So that much remuneration he can keep it for himself, and the rest he has to give it to his principal. Clear with this? This is what section 219 of Indian Contract Act says about the agent's remuneration, right to remuneration to the agent. There is also one more rule saying that whatever it is, till the remuneration does not become due to the agent until the work is completed. If the work is completed in full, till then he won't be entitled to get his remuneration. This is one more point which has to be noted under section 219. But this rule is subject to special contract. If there is any special contract regarding this, that no, before completion of work, certain work only, you may get your remuneration for the agent, then he is entitled for that remuneration. We have a case law for this, that is Saraswati Devi versus Motilal. In this case, there was an estate agent who said that who was approached by Saraswati Devi and her husband for selling certain estate property. They said that you find a purchaser who is ready and willing to buy this estate. Then we'll pay you certain commission. Then this estate agent, he finds a purchaser who was ready to pay 1,27,000 for the property, and they also paid rupees 30,000 in advance. Subsequently, this lady Saraswati Devi and her husband, they refused. They withdrew the offer to sell it. They did not want to sell it. So now the agent now brought an action against Saraswati Devi and her husband, saying that his commission is due. His commission was for 2,500 is due. So this case went to the court. Now it was held in the court that as per the nature of the agreement, the commission is due to the agent. What they said in the agreement? Please find a purchaser who is ready and willing to pay. When do you normally pay to the agent, estate agent, after the sale, right? But here, as per the nature of the agreement, it was found that yes, now the commission is to be paid to the agent as per the whatever the transaction has taken between Saraswati Devi and the agent. So the commission became liable here. Clear with this case? We'll proceed to the next one. So the next one is right to retain sums. Right to retain sums. Before that, we have one more point. No remuneration to the misconduct. That's given under section 220. Section 220 gives that there is no remuneration given to an agent who is found guilty of misconduct in respect of that part of a business which he has misconducted. So if there is any misconduct done by the agent, then no commission for that or no remuneration for that agent. Now let's take an illustration for this. There is a person A who employs B. B is the agent, A is the principal, to recover certain sum 10,000 from C. A says, please go recover from C 10,000 to B. This B, he does some misconduct and the money is not recovered from C. Now don't you think B is not entitled to any remuneration? Because he has not rendered, he has not done his service properly. He has done certain misconduct. And he must make good the loss to the principal. So principal has incurred certain losses due to his misconduct. That is, he has not recovered properly from C. That is why now B becomes liable to the to compensate for the principal for the losses occurred due to his misconduct, as well as he is not entitled for the remuneration. So I hope you're clear with right to remuneration under say section 219 and no remuneration for misconduct under section 220. Now we'll proceed to the next one. The second right to retain sums. Right to retain sums is given under section 217 and 218 of Indian Contract Act. What it says, what is basically to right to retain sums? I have been telling you. When he has got a right to remuneration, if at all his remuneration is not paid, he can retain the goods, whatever is with him that is given by the principal. That is what is explained again. So, right to retain sums means section 218 tells us that the agent has a duty to pay to his principal all the sums received on behalf of principal's account. So, whatever he has received on behalf of the principal, so he has to give it to, it is his duty to give it to the principal for all the sums. So that is given under section 218. But an agent has a right of retainer. He can retain out of sums received on principal's account. We have discussed this earlier. He can retain certain amount. What are those amount? So all the monies due to the agent for the advances he has made. Suppose if he has given any advance, then he can retain from that particular money, that is principal's money. Or if he has incurred, if any expenses incurred by him, in case if the agent incurs any expenses, then also he can retain the money. And if any remuneration is payable to the agent, that also he can retain from the money which he has got by doing the business for the sake of the principal. Before he gives it to the principal, he can retain certain amount. Clear with this? The section 217 says that all the monies due to the agent in respect of any advances made or expenses properly incurred by him in conducting such business, and also remuneration which is payable to him for acting as an agent, he can retain it. That is what your section 217 and 218 says. I hope you are clear with this. Now let's move on to the next point. That is right of lien on the principal's property. That is given under section 221. It says that in absence of any contract to contrary, an agent is entitled to retain the goods, papers or other property, that is both movable or immovable, of the principal which is received by him until the amount due to himself for commission or disbursement or service in respect of the same has been accounted for him. That's given under section 221. Now let's try to break this and understand what it says in case of absence of any contract which is contrary. So if there is any contract made not relevant, if it goes against whatever is given under section 221, then he cannot have that lien on the property. If there is any contract, I'll explain this later. So it says that if there is any contract existing to the contrary, till then he cannot recover. If there is no contract which is contrary, then the agent is entitled to retain the goods. He can keep the goods in his possession itself. Or if at all there is no goods, he has got certain papers, he can keep the papers. Or other property which may be movable or also immovable. But it has to be received by the principal. Until the amount. So until the amount becomes due to himself, until there is any due amount himself for some commission or disbursement or service in respect of same has been paid or accounted for him, till it has been for his services, until the remuneration is paid, till then he can have the control of that property. That is given under section 221. Right of lien is meant to make. Why is this right of lien is done as the main object is it is meant to make good the expenses incurred by the agent during the exercise of his power. That is, if he is entering the contract and if he has incurred any expenses in order to make good the loss, he is not benefited by any ways by entering the business with third party. It is the principal who is benefited. So he is giving the money to the principal. So now it is the duty of the principal to pay him certain commission for his services. So till the amount is paid, when the amount becomes due until it is paid to the agent, till then he can keep the property with himself. This particular right to lien on principal property can come to an end under following circumstances. There are three circumstances when it can become, when it can come to an end. The first one is in case if the agent loses the possession, he lost the possession of the goods. As soon as he loses the possession of the goods, his lien comes to an end. The first point. Second point is when he has extinguished by waiving off. He says that he gives a waiver saying that no, I don't want to exercise the right of lien against my principal. As soon as he gives that, then even if it is by express or by implied mode, as soon as he waives his right, then his right to lien comes to an end. The next is when the agent's lien is subject to the contract. If there is any contract that excludes that he cannot, that right to retain principal's property, that says that you cannot retain the principal's property, then his right comes to an end. So these are some of the conditions or when does the right to lien on principal comes to an end. Point number one is it comes to an end when the possession is lost. Point number 2 is when he gives off the right, when he extinguishes the right of waiver. He says that no, I'll waive off this right, I don't want this. And in third case, when there is a special contract saying that no, I'm okay. The agent says that yes, I'm okay at the time of entering the agreement, and the contract between the principal and the agent for the agency relationship. If the agent says that no, I don't want to exercise any right of lien on principal's property in case of dues, then it comes to an end. Clear with this? So right of lien means the agent can retain the goods till his dues are cleared. That's all. The next one is right to be indemnified. That's given under section 222 to 224. What is indemnified? We have studied this earlier under contract of indemnity. Indemnity means make good the loss or to compensate. Now what is that right to indemnify? So here when you're speaking about the agency, an agent is entitled to be indemnified. He has a right to be indemnified by the principal against all the lawful acts which is done by him in exercising his authority conferred upon him, that is given under section 222. So if at all he has spent something, there is some expense incurred to the agent in doing the principal's authorized work, then, and it should be lawful also. One more point to be noted under section 222. If it is lawful and he has been authorized and if he has incurred any expenses, then he has a right to be indemnified by the principal. It is the Now let's take an example for this section 222. There is a person A who is in Calcutta. He is the principal. And he has his agent in Singapore, that is Mr. B. He instructs, the principal instructs the agent B to deliver certain goods and enter a contract for that. So this B enters a contract with C. Then later on, C enters a contract with, he also agrees to enter the contract with B, and they mutually agree. And now the B has entered into a contract in A's name, that is the principal's name. Now it is the duty of A to deliver the goods to B and B in turn deliver the goods to C. This A, the principal, does not deliver the goods at all. He does not send the goods. Now this C, after waiting for some time, he files a suit against these people, that is B and A, for the breach of contract. B informs regarding the case to his principal, that is A. A says that, okay fine, you defend my case, then I'll pay you all the necessary expenses. Now this person is B, he defends the case. For defending the case, he had to pay certain cost and therefore incur certain expenses. Now, what do you think? Who has to pay for the expenses of Mr. B? It is Mr. A, because he is defending the case for Mr. A. He is the agent of A and he is authorized to do this, that is defending the case against C. Therefore, now for all the losses, all the expenses which is incurred by the agent Mr. B has to be paid by A. So this is one best example which you can easily remember, section 222. Now further, if you go further regarding this indemnity, you can find section 223 which says that can the indemnity be paid for any civil wrongs or tortious act? That's given under section 223. Now, how is this tortious act? Can the agent be indemnified? All this question may come in your mind. It says that if the agent is entitled to be paid remuneration, indemnified, we're talking about indemnification. So he is entitled to receive the indemnity amount by the principal if the agent has done any injury to the third person on the saying of principal, if the principal asks him to do certain act and this agent in good faith does it, and if it causes injury to the third person, then who has to pay for that? It is the principal who becomes liable. It is the duty of the principal to indemnify under certain civil wrongs. Now we took the previous example itself. What happened in the previous example? He failed to deliver the goods. There is a breach of contract. Then who has to pay for that? It is the principal who has to pay for it. Clear with this example? There is also, you can even include this example also, Adamson versus Jarvis, which we discussed in contract of indemnity, where a person is an auctioneer, plaintiff is an auctioneer, and this defendant, he approaches the plaintiff, himself posing as a owner of the cattle, to sell it and give him certain money. After selling the cattle, the real owner comes and says that, how could you sell my cattle since I am the real owner of this cattle? He files the case against the plaintiff, that is the auctioneer, and the auctioneer has to pay to the real owner. Then in turn, this plaintiff files the case against the defendant, saying that he has to compensate for the losses which the plaintiff has incurred. The court established the relationship of agent and principal, that is the plaintiff, the auctioneer becomes the agent and the defendant has an principal, and therefore the principal became liable to compensate for the losses incurred by the plaintiff. This is also an apt example for this section. Section 223. There he is misrepresenting, the defendant misrepresented, telling that he is the real owner. Right? Got it? Now coming to the criminal offences, relating, is he liable for any criminal offences? That's given under section 224. It says no indemnity for any criminal offences. Suppose the agent is employed to do any criminal offences. So still, if he is authorized by the principal to do it, he is not entitled to receive the compensation, or he is not entitled for to be indemnified from his principal. The agent cannot ask for it. He cannot go through law also to demand for that money. Neither for any criminal offences he cannot ask for that. We'll take an example. Suppose A employs B in order to beat C. He does that. He does whatever the principal is saying. Now he approaches the principal to give him money. Do you think he can be indemnified? No. He cannot be indemnified, even though he says he won't indemnify, and if the agent approaches the court, there also his case won't stand. He won't be getting any sort of compensation since it is a criminal offences. It is not valid. Clear with this? Then we'll go to the last point, that is right to compensation. It is given under section 225. What it says that right to compensation for damages, for any damage due to the principal's neglect. If there is any negligence caused from the principal side, then the agent can receive any compensation. If there is any injury caused to the agent because of principal's neglect or want of skill, he does not send on time the goods which he was supposed to send. The principal had to send. He does not pay. Now the agent pays compensation to the third party. Who has to compensate for the agent now? It is the principal. So for any injury caused to the agent due to the principal negligence or want of skill, then the principal becomes liable to pay for the agent. That is the principal duty to compensate for the agent. The agent has a right against the principal. But there is one more condition to be noted here. But the agent cannot get compensation if the injury results from his negligence. If there is any negligence on the part of the agent, he cannot receive the compensation amount. Or he knows that there is risk in this particular business which he is doing. If at all he is aware of it, but still he does not take any care, then he is not liable. It is one of the duty of the agent to take reasonable care of the goods, right? If at all he does not take care, then the principal is not liable to pay for the losses. Now let's take an illustration and let's try to analyze how this compensation works. It is a very simple example. A employs B has a bricklayer for his house. He is constructing a house and he has him to be a bricklayer, and he puts up a scaffolding by himself. That is, he himself puts up the scaffold. Whatever the scaffolding he has put, it is not put skillfully. It's unskillfully put up. And B in consequences is hurt. The A has put it, even though he employs B, A has employed B as a bricklayer. This person A puts some temporary adjustment for that, some temporary adjustments he made, and during that he is not skillful in that, and during that the B is hurt. Now who has to compensate for B? It is A who has to compensate for A. It is the negligence of the principal. So he has to pay for it. He has to compensate for it. So now let's have a quick revision of rights of agent and duties of principal. Always remember, whenever there is a right of agent, it becomes the duty of the principal. Whatever is the right of the agent, it is the duty of the principal. The first right is right to remuneration under section 219 and no remuneration for misconduct under section 220. Then right to retain sums, that's given under section 217 and 218 of Indian Contract Act. Right of lien on principal's property, that's given under section 221. Then we have right to indemnity, which is given from section 222 to section 224. Then the last thing is right to compensation, that is given under section 225. So these are the important things, that is rights of agent.